businesses with their immigration needs. And Lisa is a co-founder of that practice, and she's working with her partner, Monica Lugacek, and they have handled over 25,000 immigration matters. She is one of the first women and only Spanish-speaking California bar immigration and nationality law certified specialists in Orange County. Be glad I'm not your speaker today because I'm nervous up here. Anyway, please welcome Lisa.
Okay, can everyone hear me? Okay, great. For those of you in the back of the room, I highly encourage you to come forward because if you have questions, I may not be able to hear you. So we're kind of a smaller group and there's plenty of seats available up front. First, I just want to commend you all for taking the time out there. I know there's a lot of other sessions going on to really get a refresher on the I-9. Can I get a show of hands in terms of how many people in the room assume the responsibility of your I-9 policy and processes? Okay, great. We used to call the I-9 the simplest, most complicated one-page form. We now call it the simplest, most complicated two-page form. And I might add the most costly. And I think the importance, I recognize that HR professionals have a lot of other responsibilities on their plate, whether it's, healthcare and unions and other employment-related issues and concerns, changes in the law. And I will tell you, we often find that employers kind of don't necessarily prioritize the I-9. It's like, oh, how hard can that really be? And I just, again, want to emphasize the importance of this form is not so much in, the completion, but it's that it's completed accurately. Because if your organization is ever subject to a DHS audit or investigation, they are extremely meticulous in terms of how they go through your forms. And so even though you may not have one single unauthorized employee on your workforce, they will still ding you and fine you for technical violations. And we'll talk about that in a minute. So for those of you who may be new to the HR field and may not understand the purpose of the I-9, the I-9 was designed and instituted by Congress, who basically felt that employment was a main magnet that attracted individuals to enter the United States unlawfully. So to kind of eliminate that magnet, they basically made employers responsible for verifying the employment eligibility of their workforce. So effective in November 6, 1986, every employee hired after that date must have a Form I-9 completed. This is what the I-9 looked like before. All of you should probably be familiar with this. And this is the new I-9 form. So what are the changes that have taken place with the most recent revision that took place in March? Although the form came out in March, effective May 7th, employers are required to use the newly revised I-9 form. And that goes not only for newly hired employees. If you're handling any re-verifications, you must do those re-verifications on the new I-9. So if you have any blank old I-9 forms kind of hanging around that you used to just easily pull, you want to make sure that all of those, again, the ones that are not completed, are shredded, purged, or destroyed. If you have anything that's completed, you want to make sure that those are filed and retained. The form has gone from a one-page to a two-page. They've expanded some fields. They've reformatted the date. What DHS had found was a lot of foreign workers, especially in other countries, they reverse the day and the month. And so to make it very clear in terms of how that date should be completed on the I-9 form, they specify that it needs to be month, day, and year. There's new fields for email address, phone number, passport, and country of issuance. They've expanded the instructions, and they have revised the handbook. And again, I just highly recommend, if you haven't already become familiar with the handbook, the M274, that you go back to your office, Google. It's available online. It's many pages to print out, but you can easily access it online. The good news is that the list of acceptable documents has not changed. So if you're familiar with your List A, your List B, your List C documents, then those have not changed as a result of the revised form. Friendly reminders, Section 1, the employee must complete Section 1 by him or herself, and they must complete it on the first day of employment. So it's perfectly acceptable if you want to send the I-9 form, instructions, the list of acceptable documents in advance. If you have a package of pre-employment, they can have that so that they can come prepared on their first day of employment to present those documents. They may complete after the job offer is accepted, but never before. So you don't want to send it to prospective employees that you haven't actually made an offer and they haven't accepted that offer. There's been some changes with the last and first name field changes. The maiden name is now called other names used. The address field has been modified, and something that's been clarified in the instructions, it must be a U.S. address. Only commuters from border locations from Mexico and Canada can use foreign addresses. It cannot include a P.O. box. So you want to make sure that they are specifying their specific physical address. And they can, if you have some remote location or employee that works in a rural area where there may not be an address, they can specify, a description of where they live, 3 miles off the highway next to the water tank. So that address field does need to be included, and descriptions are allowed if they don't have a physical address. They've revised the Social Security number field, where it actually contains 9 boxes to enter each digit. They have optional fields for email addresses and telephone numbers, and they have the A number and USCIS number included. And one thing I just want to clarify, that if the employee is a lawful permanent resident, for example, and they do provide their A number in Section 1, you are not permitted to therefore ask for that document if it's not one of the documents that they're choosing to present. So you want to be very careful. Should they choose to put in that alien number, that's their information. You can't therefore request their lawful permanent resident card. Was there a question? No? Okay. So USCIS stands for U.S. Citizenship and Immigration Services. So most of you, or maybe some of you, may be familiar with the INS, which was the Immigration Naturalization Service. Back in 2003, the INS has ceased to exist. So we'll talk about that in a minute, but if you're continuing to get employment authorization documents that still have INS on there, it should be an immediate red flag. And USCIS is one of the 3 bureaus under the Department of Homeland Security. So typically when a person has an employment-based petition filed, or they're issued their lawful permanent residence, or they've gone through the naturalization process, they're doing all of that through USCIS. And so they've called it the USCIS number. It is the same as their alien number, is what it was previously called. Yes? Permanent address. That's a good question. So you can't dictate in terms of what address, but they need to have a legitimate address, even if it's a temporary one, of where they're staying or residing in the United States. But if you're hiring somebody from overseas and they're moving here, they may still be looking for permanent housing, but they should have a place where they're physically residing, at least for the time being, and then they can always update that information should it become necessary. Well, E-Verify has its own set of regulations, and you do need to have that posted that your company does participate in E-Verify. So yes. Going on with Section 1, there's a new I-94 admission number. We'll talk a little bit about that in a minute. There's a 3D barcode. Now, none of us are absolutely sure in terms of what that 3D barcode exists for. Nobody knows. But the government, and specifically USCIS, is moving in the direction of barcoding all of their forms and petitions and applications. So my guess is that at some point, and the other thing that leads me to believe this is if you ever access the I-94 online, despite the fact that they don't want Section 1 pre-populated, you can actually physically type into that section. And so what that leads me to believe is that eventually down the road, there's going to be a way of completing the I-9 where it will produce an actual barcode that the government can easily scan like they do several of their other applications. There's the employee signature block, I think to make very clear. Oftentimes we saw employees signing above the box. So now the new form makes it very clear in terms of where the employee signature belongs. They've added stop icons to the bottom of section 1 to make very clear that at this point, this is where the employee needs to stop completing that form despite the fact that it has a second page. The instructions clarify the use of preparer translator section. Again, as exciting as it may be for some of you that the I-9 form exists in the Spanish language, unless you're in Puerto Rico, you are prohibited from using that form, despite the fact that you may have an employee that could very easily read and complete the Spanish form. You cannot use the Spanish form as a substitute for a translator or interpreter either. So it's really important that you not begin to use that. If you have used it, then you need to make sure an English form is completed. In terms of the preparer translators, the instructions make clear you can delegate the responsibility to a third party to verify documents. You just need to make sure that that individual is completing that section. There's some new information available for the use of minors and disabled employees. If you have a minor on your staff that does not have a photo identity, and they are under the age of 18, a parent or legal guardian can indicate on the section 1 minor under 18. So they can not sign for them in terms of their name, but they can indicate that they are a minor. The same thing goes for any disabled employees that you might have that don't have photo identity. You can indicate special placement on the signature. The pre-population of data in section 1 is highly discouraged, and I would recommend against it. DHS really doesn't like to see that information completed because they want to make sure that it's the employee that's providing that information. Friendly reminders as to section 2. Again, you may not specify what documents the employee can present. They get to choose. And you must physically review original documents. And I can't emphasize enough. We recognize in today's day and age that there's a lot of telecommuting. You may have workers working from home or off-site. They may be in another state, and it may be difficult and problematic for you to be able to verify those original documents in person. However, verifying by Skype and webcam is prohibited. As convenient as you think it might be, let me just see your document, it looks like it's an original and you accept it, is not allowed. So if you need to make arrangements, again, for a third party to do the verification as an agent of the employer, whether it's a notary local to where the employee is located, you can do that, but you cannot substitute fax copies, scanned copies. You can't substitute for original, and you can't make a substitute for needing to be physically reviewing those documents. You want to be careful not to over-document. I think all of us know that we have some eager employees that bring us, probably every possible document on every list that they have, and that's great, that's wonderful, but you need to emphasize that they need to provide a list A document or a list B and C document. Should they attempt to give you more documents, just let them know you need to only get a list A document. They can choose from whatever they want. You want to be careful not to over-document. Let me ask just a show of hands, how many people in this room have a policy to photocopy the employment verification documents? To photocopy. Okay, so it goes, it can go either way. Either way is perfectly permissible. And we often get asked, well, what is the better way to go? Is it better to photocopy documents and attach those photocopies to the I-9, or is it better not to? And I always say, as any good lawyer would, it depends. And what it depends on primarily is how good and how effectively trained your staff are that are responsible for the I-9 verification. And the reason is that if they are very good and they know what a list A document is and they know what a list B and C document is and they're attaching the appropriate documentation, it can actually help you in the event of an audit or investigation. It can show, wow, this really does look genuine, on its face. It appears to relate to the employee. This fooled us, but the person's, not authorized to work nonetheless. But there's no way, they don't expect you to be forensic document analysts. It's really difficult, and some of the fraudulent documents are very good, but so the keeping the copies could be helpful. On the other hand, we've also seen it go the other way when you don't have very well-trained staff that are responsible for the I-9 process. And what results is, they're making copies of whatever document, they're over-documenting, and they've got now that evidence. They've got, employment authorization cards that say it's a woman with a, gender of a man. It's got dates that, it still says INS, and it was, not valid for another year in advance, much less having been valid at the time of the verification. I mean, we've seen it all. So it can actually come back to hurt the employer because both it can affect their actual knowledge. DHS can find that the employer actually knew that the person was not authorized to work, or they can find that the employer had constructive knowledge. They should have known because these documents clearly are fraudulent, etc. So it can go either way. You just want to make sure if you do make copies, either way, you're not over-documenting. And if you don't take copies, again, that you're not over-documenting the I-9. You must make copies of documents with photographs if the employer uses E-Verify, so I just want to articulate that exception. Unless E-Verify is used, you cannot request any document with his or her social security number. So despite the fact that Section 1 requires the employee to put their social security number, if they choose not to present their social security card as a form of employment verification, you can't ask for that. So it's, again, something you want to be very careful of. The employer must sign and date Section 2 no later than the 3rd business day from the employee's start date. And I'm going to mention a very specific rule regarding that in just a second. The instructions, again, clarifies who's an authorized representative. They've added employee name fields. So what they've made very clear is now the employer is responsible for basically copying the name of the employee from Section 1 to Section 2, that it is permissible on Section 2 for you to complete that specific field. They've added more space and new fields under List A, and they've repeated fields for List B and List C and names purpose of each list. And I think this is really helpful because what we saw a lot when we would do audits for some of our clients is that they would mix up the B and C. It's like, well, which one was the identity? And they're trying to then draw arrows because they mixed up the columns. Now it makes it very clear. List B documents are identity. List C documents are employment eligibility. The 3-day rule is indicated in the instructions, and this is something really important. So because the employer is required to complete Section 2 by the 3rd business day, that 3rd business day is defined by your operation schedule. So if you're a business that operates 7 days a week, despite the fact, and that 3rd day falls on a Saturday or Sunday, despite the fact that there may not be HR personnel on staff on those days, you are still obligated and required to get that completed by the 3rd business day. So if that means you need to have, some cross-training where someone else who is staffed to complete that section when you're not in the office on the weekends, or if there's no HR personnel, or you need to make sure that that Section 2 is completed within the 3 days, whether it needs to be done by that Friday. But again, you have 3 business days, and it's not what we normally have been accustomed to thinking Monday through Friday. The business days are dictated by your business days. Question?
2 quick questions. First of all, when it's 3 business days from the start date, does that mean it started on Monday,
Is
Wednesday,
one.
or is it Thursday?
No, it's 1. So 3 business days, the first day counts, the first day of employment, the second day, the 3rd day, by Wednesday. And DHS is very careful about reviewing those dates when they go and perform their audits and their investigations. Yes.
Business day is defined as any day on which you have employees at work, even if you're not open for business.
It goes by operation schedule. So if you're open, if it's a business day and you're open, you're producing your work, there's work being performed, that would be considered a business day.
So a person, let's say it's just the boss and there's one person on 20 that's working overtime that day. Do you consider that a business day, or you're just...
No, if the entire office or operation is not open and they are actually the exception to the rule, then that would not be considered a business day. But if it's a general operating day, then it would be considered a business day.
Good example, I hired 3 people on December 30th, which was a Monday, and December 31st, the first week closed on holiday. I live in a state where I don't have an office. Can I designate for spouses to be an authorized person to verify my information?
I would discourage you designating, you can designate an agent, that's what the instructions said. I guess you could technically designate their spouse. I would highly discourage it.
Would you go to
A notary?
Notaries will do it. I'm a notary.
You won't verify someone's? There are notaries who will do it, and notaries regularly do it, so you may need to find one who will do it. Or some other third party. I would not have it be someone who has an interest in the verification. A spouse would obviously vouch for their husband whether or not their documents were legitimate, so you want to be very careful. Just to give you some history and some ideas for those of you, how many people here have a large number of foreign employees? Okay, so about half. It can be very challenging, I think, especially with the vast number of visas and documentation that the Department of Homeland Security can provide to indicate that the individual is eligible to work in the United States. And I just kind of want to give you some examples of maybe some of the most common documents you may see and how it's evolved over the years. So this is the very first, what we commonly call green card. It's actually the reason why we call it green card, because it has like a light green background in the photo. It was first introduced in 1946. It would be very uncommon for you to still receive this card. However, it doesn't have an expiration date and is still technically valid as a form of employment eligibility. In 1977, the resident alien card was introduced. It also does not contain an expiration date and would also be considered a valid form of employment authorization. Then in '89, we saw this card that actually does have the expiration date. And therefore, at the time of the I-9 is being completed, it does need to be valid, meaning it cannot be expired. But one thing I also want to emphasize that you are not permitted to re-verify lawful permanent residents or U.S. citizens for that matter if they were to present a passport that may have an expiration date at some time in the future. It does need to be valid at the time that the verification is taking place. Pre-2009, you were allowed to accept expired documents. That is no longer the case, so the passport or the lawful permanent resident card needs to be valid at the time of the I-9 is being completed. However, should that have an expiration date, as all passports and now the newer lawful permanent residence cards do, you do not need to re-verify that individual. They do not lose their status, they don't lose their citizenship, they don't lose their lawful permanent residency status just by the mere fact that their passport or their lawful permanent resident card has expired. This is the look of the employment authorization card. We've seen all sorts of cards. If you ever get an employment authorization card that has a validity date sometime in the future, know that it is not a legitimate card. The government is never ahead of the game. We've seen it. We've seen these cards that, it'll be valid from, December 2014 until, December 2016. It's like, well, wait a second, that can't be. You also want to make sure that, INS hasn't existed for 10 years. They no longer issue employment authorization cards with INS, Immigration Naturalization Service. Everything should indicate that it's Department of Homeland Security. The validity dates are typically for employment authorization cards 1 to 2 years. It's rare, not that it's not possible, but it's rare really to see a card that is issued for an extended period of time. Some of you may be familiar with the I-94. This paper version of the I-94, again, not to be confused with the foreign employee's visa. Okay, so the visa dates don't always coincide and usually don't coincide with the I-94, but it is the I-94 that dictates their employment eligibility period. Now, one thing to be mindful of, as of March of this year, this paper I-94 has ceased to exist. So you're going to see fewer and fewer of these. Now everything is electronic. So Customs and Border Protection has now changed the procedure for any individual entering the United States. The employee would be responsible for going online, and you can see the URL, the website address is there. It's a very simple and easy process that they, type in their basic information, and they can print out their I-94 card, if that's what you want to call it, their I-94 form, so that you can see it or use it for employment eligibility purposes. Okay, friendly reminders pertaining to re-verification. The only time you really need to re-verify an employee is one of three situations. Either first, the employee has presented an employment authorization document with an expiration date. You want to make sure you have a very effective and reliable either calendaring system or tickler system. If you're using an I-9 software program, generally all of those are built in. But if they have an employment authorization document with an expiration date, you will need to re-verify that employee. And we really suggest that you give them as much as 6 months in advance. Some people say 120 days, and then periodic reminders that this documentation is going to expire and that they need to present additional employment authorization documentation. Now, 2 points. One is you don't need to re-verify the identity. Once you've done that once, you don't need to do it again. You are strictly re-verifying their employment authorization. So you want to make sure that you're not, again, asking for a List B document once the identity has already been established. The second thing is, I just lost my thought. They don't need to show you the same, so if they have an employment authorization card, for example, that's now expiring, but they want to show you a different employment eligibility authorization document, they can do that. That doesn't have to be the exact same form. You just want to make sure it's either a List C document that they do provide. Did you have a question?
We just hire a new employee, and she has a employment authorization, and she got a letter saying that it's in the process from the attorney, and do we see that information or is she okay to consider it?
Yeah, if you don't mind, I'm going to hold on to your question because I actually cover receipts and how those can be utilized. The second instance where you would need to re-verify an employee is if you've been contacted by Department of Homeland Security, you've received a notice of some kind or some other federal agency, and I'm not talking about Social Security no-match letters, but that they have explicitly indicated that they believe that this individual is not authorized to work in the United States. To protect yourself or the company from any liability, you're going to want to re-verify that employee if it's at the request of the federal government. And then the third instance when you would need to re-verify is there are certain situations when employees can present receipts. Either they filed an extension of status for an H-1B and they are able to work, but you would need to re-verify them if a receipt has been presented 90 days from that date so that they can show you the actual physical document. And I do want to clarify, initial applications for employment authorization, so typically you can accept a receipt from an employee. They would be subject to re-verification if a document, even if it's like a driver's license, has been lost, stolen, or destroyed for some reason. But you do need to follow up because they will need to show you that actual driver's license once they have it. The same thing goes for the employment authorization card. However, if it's an initial application for an EAD, you cannot accept the receipt. So that's kind of a unique thing. But so it's a little complicated, and again, the handbook goes into great detail in terms of what receipts you can and can't receive, and I would spend too much time going through the list right now, but specifically as it pertains to employment authorization documents, their initial application, the receipt alone, and surely not a letter from their attorney, is sufficient to establish eligibility to work in the United States. Employees with temporary work authorization who have filed extensions is what I just talked about. In certain categories, they can present a receipt, but they are subject to re-verification. In Section 3, they've added a new format to the name field. They've clarification to accept List A or List C documents, which I think is great because now you know, well, there is no List B because you're not supposed to re-verify the identity. There's no place to put it. And then there's a new print name field for the employer to be able to complete, because before it just had the signature and DHS had no idea, or the employer oftentimes didn't know who was the person who re-verified that individual.
I've had situations where they brought in a list B and C document, but the C document was like a social security card that said it wasn't valid unless they had, I forget the exact wording, but essentially
Yes.
a list A document.
Well, so it's not a list A document. Typically, it'll say not valid without DHS employment authorization.
Exactly, yeah.
And that is the one exception when you actually can ask
Okay.
for that employment authorization card, because
And then when we fill it out, we just fill out list A because,
it's not list A. So you're doing a list B and you're doing a list C.
so the social would be the C and then the DHS authorization would be
With
the
the
list A.
DAD would be their employment authorization card. It would have to be with the C.
Okay. I guess I thought the employment authorization card was a list A document.
It is not a list A
Oh, okay,
document.
okay.
No, it's not a list A document. Something that we get often asked is if an employee changes their name, are they subject to re-verification? They get married. The DHS and the regulations and the instructions make clear the employer is not obligated to re-verify an individual because of a name change. Whether they legally changed their name, they went through the legal name change process, they naturalized, meaning they became U.S. citizens and they changed their name during that process, or they got married and they changed their name. You're not obligated. However, we highly recommend that you at least make a notation. If the employee comes to you and says, hey, my name is no longer Sally Fields, it's Sally Jones, it is a good idea for you to get in the practice of indicating in Section 3, Sally Jones, now Sally Fields, per marriage on blah, blah date. You don't need to take copies of documents. You don't need to ask for additional documentation. However, I generally recommend that you make that notation, because in the event that you're audited or you're being investigated by DHS, you want to make sure your payroll records coincide with your I-9. And if there's no notation that, Sally Jones is coming up on your payroll record, you don't have an I-9 for, not to say that you can't correct it, but it's just a lot easier if you've got either a memo attached or you've got a notation made on the I-9 form that Sally Fields is now Sally Jones, and therefore there's a match between your payroll record and your I-9. I also recommend that if an individual just comes to you, and this does happen, where they just say they changed their name and they don't really provide an explanation, I think it's important for you to be able to ask for documentation of that name change. So whether it's a marriage certificate, whether it's their legal name change document, something so that there's identity theft every day, and so you don't want somebody to just say, oh, okay, well now, they were using someone else's social with, Sally Jones, and now they're like, oh, okay, they found out it actually belongs to, Maria Shriver, and they're like, okay, well, I just need to, my name's now Maria Shriver. And it's like, well, no, because you could be on the hook for having constructive knowledge that this person really isn't who they said they are. So you want to you don't need to copy it, you don't check, you want to make a notation of that name change and what, if any, documentation they provided to verify or validate that name change. Okay, now I've been made aware that in your book there's a duplicate slide and that this slide is missing. I just want to bring to your attention that there is a helpful hints checklist on page 108 that this information is also on, so if you want to turn to that, and we'll go back to the other slide. Again, employers, when you're making corrections on the I-9, you can only correct errors made in Section 2 or Section 3. We generally recommend, if you do discover, whether it's through an internal audit, that there are corrections that need to be made to Section 1, just make sure that the employee is the one making those corrections. So let's say, for example, their birth date was incorrect. You're going to want to follow these rules both for when they make the corrections and when you make the corrections on the I-9 form. So generally, you just want to draw a line through the incorrect information. You would enter the correct information. We recommend that you use a colored pen, like a red pen. You want to initial and date those changes that are being made. And if, for example, the form is just a mess, you realize, I don't know who was responsible, but this was before my time, and it's just a disaster, you do have the option of completing a new I-9 form. You want to make sure it's the most recent version. You're going to attach it to the old one, and you're going to attach a memo along with it, explaining the situation or circumstance of how you discovered the errors and what steps were taken to correct any mistakes. So, for example, you would say, during the course of an audit on July 31st, 2013, birth of employee was noted to be incorrect. So if you can make the correction on the form, great. Just draw a line, initial and date. If it's section 1, it's done by the employee. Section 2 or 3, it's done by the employer. Or if you need to complete a new one and attach a memo, you can do that as well. I also want to point out on this slide there's a typo. It says May. It's supposed to be March. So May is the date that it went into effect to use the new form, but the form's date is actually March. So you want to make sure you're using the March 2013 version only. I don't want anyone to go back and say, I can't find the May 2013 version. Where is it? I can only find the March. It doesn't exist. So I apologize for that typo. Okay, maintaining compliance in terms of the retention of the I-9 forms. You want to make sure, under no circumstances do you ever destroy, purge, or shred an I-9 form for a current employee. I don't care if you need to correct the I-9 form 2 or 3 times over a period of time. You don't ever destroy the original I-9 form for any current employee. You want to make sure that you keep your I-9 forms for your current employees separate from your terminated employees. And you want to make sure that those forms for your terminated employees are in a calendaring or tickler system that lets you know when you can actually purge them. You don't want to have, some people, I get it, they're record keepers and they want to keep everything forever. That's not a good idea when it comes to the I-9, because when DHS comes in and gets all those I-9s and half of them could have been purged 5 years ago, you're still going to get dinged for every technical or substantive violation on those I-9s, regardless of whether you should have kept them. So you want to make sure that you follow the rule, that you keep the form on file for 3 years from the date of hire or 1 year after the last day of work, whichever is later. And again, emphasize it's important to keep that in a tickler system or calendaring system so you're purging as quickly as you can. Again, not to purge anything for current employees. You want to make sure the I-9 forms are separate from all other personnel and payroll records. Look, I understand you may have a legitimate reason to ask an employee for their driver's license, whether they're going to be, utilizing a company vehicle, and you may need that for hiring purposes, payroll purposes. You may need that for something else. But just distinguish that process from I-9. You're not going to want to over-document your I-9. You're not going to want to ask for the driver's license as you're, completing the I-9. It is a completely separate process, and those documents should be kept separately. So you never want to keep the I-9 form with the personnel files. DHS is going to think, wow, you really did ask them for a lot of documents for the I-9, when really, in reality, you were asking for documentation for other purposes and reasons, employment related, but not related to the I-9. What should you do? We really recommend that you periodically conduct an internal audit, self-audit. And we also recommend that that not be done by the same person who's responsible for completing the I-9. We're terrible at catching our own mistakes. And so you need a fresh pair of eyes, whether you outsource it to a third party or if there's some cross-training in the office that you guys are verifying the completions of the I-9s as they're completed is always a good idea. The other point I didn't mention earlier, and I'll just mention it now, is when you're correcting, the Section 1, we generally think it's a good idea before an employee leaves payroll, if they've been terminated, take a glance at the I-9. It'll be the last chance you have for them to make any necessary corrections to Section 1. Because once they're gone, and if there's mistakes or errors, you're going to be on the hook for them. So it's always a good idea. Just take a glance at it. If it's something that needs to be corrected, then they can correct it before they depart. Review and update personnel and I-9 compliance policies and procedures annually. You want to incorporate no-match, safe harbor procedures and policy against discrimination. So there's so much we can talk about at the I-9. Right now, I'm just strictly talking about substantive and technical violations, but you can get hit for violations for discrimination, for document abuse, fraudulent documents. There's all sorts of reasons. So you want to make sure that your policy is incorporating, as much as possible. You want to make sure that you're consistent. So for example, if your policy is to accept a copy of documents for I-9 verification purposes, you want to make sure that you're doing that for all employees across the board. And let's say tomorrow, for whatever reason, upper management, HRVP decides, you know what, we're stopping copying, the identification documents or employment authorization documents as for purposes of I-9. That's perfectly fine. Document it, put it in a memo. You want to keep it with your current I-9 files or folders or notebooks or binders, however you're filing them, so that DHS knows, well, effective this date, I-9s going forward are or are not going to have copies depending on the change in policy. So you just want to make sure that you have any change in policy documented, whether you need to update your own policy or if there's been a change in policy mid-year, then make sure a memo is included in the I-9 files. And you obviously are all here today, so you're already doing this. You're training your HR, staying abreast on I-9 compliance changes and procedures. Again, why compliance matters, I've already talked about this, I think, a little bit, but again, it's so important because it's a defense for knowingly hired unauthorized workers or having constructive knowledge, and you can avoid a lot of hefty fines, which I'm going to show you in just a minute. Go ahead, you have a question? E-Verified, you're actually required to take copies. So they have different rules and regulations of those documents. I don't believe that you're supposed to destroy them. Yeah, you're required to have them.
We kind of talked about this a little bit, but I just wanted further clarification. Can HR authorize a non-HR employee who is not a supervisor to be an authorized representative if it's at another location?
You can authorize anyone you want. Okay? And I'll tell you, and what we've seen is sometimes they authorize temp workers that had no training in I-9. So you want to be careful. As long as you're training the person and they're ensuring and someone's maybe double checking that they're, that they're knowledgeable of the process, you can really designate anyone you want.
Put that in writing somewhere that they're an authorized representative?
No, I don't think that's necessary. No, as long if they're signing the I-9, DHS assumes they're an authorized representative, and whether they were or not, you're going to get dinged and fined for the work that they performed on behalf of the company.
Is that unpaid insurance?
Yeah, I guess it could. I don't see anything that would prohibit that. I wouldn't encourage unpaid interns to assume that responsibility personally. Yeah, you remind me of a good point that I don't have a slide for here, but according to DHS, it's in the instructions, it's also in the handbook, if you have volunteers that receive any sort of compensation in the form of meals, if they're getting stipends, they are supposed to complete an I-9 form. It's something I personally don't necessarily agree with, but DHS wants to see an I-9 form for anyone who is performing work on the premises that's receiving any form of compensation. As well, if you have, international locations, you have a foreign worker, and I would say they're coming here just for training. Maybe they've got a one-day training. DHS wants to see an I-9 form for that one day if they're getting paid. Despite the fact that they may be paid abroad, the fact that they're here and they're on company time, getting paid for their time, going through a training, they want to see an I-9. So 2 little caveats I'll mention. So here are some of the civil penalties for hiring or continuing to employ an unauthorized worker. It gets expensive. Okay, so the first offense, you're looking at $375 to $3,200 for each unauthorized worker. DHS takes into consideration the size of the business, how serious the offense, whether the employer actually knew or should have known is also a factor, whether there have been previous violations. There's a list of factors that DHS will consider in terms of assessing these fines. Second and subsequent offenses go higher, and there's fines for technical violations. Technical violations, so for example, if you didn't have a single unauthorized worker, everybody was legally able to work in the United States on your workforce, but you had technical errors, so birth date was missing, maybe the fields were, mixed up, their last names and their first name, they can ding you anywhere between $100 to $1,000 per technical violation. Okay, so even though you didn't have any unauthorized workers, they can still get you. Criminal penalties also apply, and this can apply to CEOs, presidents, I've seen HR executives, and this is really when and oftentimes you're a participant in the document abuse, if you will, or not completing I-9s, and you're kind of turning a blind eye, and you say, who will ever know? The way DHS typically finds out and gets its information to conduct audits and investigations, I would say first and foremost, there's a disgruntled employee that would work for the company at a high level that had some inside knowledge of their workforce. It'll be one of the first places they'll go to complain if they're really upset and want to retaliate. Other reasons, if other workers that worked at the company previously. So DHS they're not random. They don't just okay, who are we going to pick on today? Usually they get information from what they consider a reliable source, and then they go and investigate. So here's an example where the company president, Garcia Labor Companies, was sentenced to 15 months in prison and 2 years of supervised release, fined $25,000. Another case involved a company owner and 3 managers that were arrested on criminal charges related to knowingly hire illegal workers. Look, DHS gets it. There are a lot of employers out there still that will turn a blind eye to the law and think that they'll never get caught. This is really to show you that they're serious about compliance and that they will, file both criminal charges and hit you with civil penalties should they find you knowingly or constructively knowingly hiring unauthorized workers. Civil penalties, and this is really for substantive violations. You've got I-9s, they're missing signatures, they're missing hiring dates, they're missing the box being checked on the I-9. Those are considered, because what DHS says, look, if they didn't complete this and they didn't sign it, you have no real way of knowing whether the person is authorized to work. You might as well not have had an I-9 form at all. And sometimes that's the case. Sometimes it's better to have no I-9 form than it is to have a really poor I-9 completed. Disneyland in 1993, the investigation found 1,156 violations. I don't believe they found a single unauthorized employee, but the I-9s were wrought with substantive error, missing signatures, social security numbers, missing the boxes being checked. They reviewed over 6,000 employees. Abercrombie & Fitch, some of you may have remembered, it was in the news, got hit with over $1 million fine. And this had to do with the I-9 software. Now, it is no defense to say our software had a glitch, or how could we do, the software is to blame. That is not a defense. The employer, regardless of the software that you're using, is ultimately responsible to ensure compliance. Here are some resources. Again, the M274 handbook. It's available online. The USCIS, the U.S. Citizenship and Immigration Services, I-9 Central is a great place to go for FAQs. Questions that you might have, the instructions are there as well. If you really are interested in this and want to understand better the regulations and rules, you can go to the Immigration Nationality Act in Section 274A. Our contact information is there. And at this point, I'll take any questions.
I missed on a friendly reminder updating re-verify, the third bullet point. We have...
if they present with receipts. So if they've given you a receipt, and it is actually a receipt, they've done an extension of status, for example, for an H-1B, and they don't have the I-94 updated yet, then they can present with you a receipt that needs to be re-verified so that they can present the actual I-94.
So present with receipt of what?
It's in the instances where the rules permit the employee to provide a receipt of their generally their immigration status, so it's for a foreign worker. Or if they, perhaps at the time of hiring, didn't have a driver's license because they lost it, they give you a receipt for their, then you're going to have to re-verify that to actually see the physical driver's license. That would be the other example.
You hired an employee 10 years ago, they left the company for a period of time, and you're rehiring them back. Do you have to have them redo a new I-9 form, or can you just re-verify it or back?
We generally recommend just doing a new I-9 form because you can, within 3 years of them having been let go, you said it's been 10 years though?
They were here with us for 10 years, left for 1 year, and now they're back again.
Okay, so you could complete Section 3. It would be permissible, but I think it's a better rule of thumb just to complete a new I-9 form. Especially, you're going to have to because the form has changed. So.
During my
Okay. That's a big challenge to have to correct. When the employee completed the section 1, did they complete it in their mirror? Because they're the ones that are providing the name, really, especially on the old form.
They provided their code last name, you know, they, your name is Smith, they changed it to Jackson. So they wrote down, I'm Jackson, but all of their documentation is Smith.
Yeah, if I were you, I would actually both attach a memo and do a new I-9 with that memo attached in terms of why you're doing the I-9. You want to make sure that they're accurate, they're correct, and that they're matching their payroll records, and that they're matching the documents. I mean, there's no way you can verify an identity document with one name and they're calling themselves something else. I mean, that to me is an immediate violation. So yeah, I would go back through and correct those.
When the self-audit and documentation is fair and anything,
Oh, absolutely. Yeah, any efforts that you're making to comply and to correct any, discovered errors is always going to help you. Otherwise, there would be no point to doing it.
Just for clarification, are we required to have employees exhibit new or recertify when they change their last names?
No. No, you're not required to, when someone changes their last name. In the instructions, the rules, the regs, there's no requirement that the employer really has to do anything. I just think it's a good idea, if it's not matching your payroll records, at least a notation be made or a memo attached so you have that consistency. I'm generally one to do the ink. But it's acceptable and it's permissible. Are you using E-Verify?
In some states.
In some states. Is it the same employer? Is the same EIN number in terms of when you say some states? Is it the same company? Is it the same employer?
I'm actually with the PEO, so
Oh, okay.
supporting the multiple clients on some of our sites. We don't agree with this. I sold property. I never met my real estate company. I do everything electronically.
Yeah,
So,
I just feel that the government is it's permissible. I'm going to say that it's permissible. I think the government, at least at this stage, is a little bit behind the game when it comes to electronic signatures and electronic anything. I mean, don't get me started, but yeah, it's permissible. That's all I can say.
I have a population workforce where they have like several last names, or their middle name is the last name, or their mother's maiden name is their last name, and their social security card is one name, their driver's license is another last name. Which name are they supposed to use on 99 form when some of their documents are different? One shows middle name, and the other document shows the same name as, but that's last name, not middle name.
Yeah, it's a challenge. It's a challenge. They're the ones that are going to put what their legal name is, right? So they're completing that section 1. Your job is to make sure that the identity document, or if it's a listing document, or that it reasonably appears to be genuine and relates to the individual. So if it has a
Verify, and then sometimes that's a problem.
that it is going to be a problem. It's absolutely, and it's a problem that they're going to have to fix. The burden really falls on the employee in this instance, as long as you're, providing them the notice that this flag came up and they need to take care of this.
Second question on 99, I think you touched about this. These employment authorization cards,
Uh-huh.
are these not good?
Those are good.
So when they said to, from, as far as,
The validity dates at the bottom? Yes. So yeah, as long as it's valid at the time that the I-9 is, the verification process is taking place, it's fine, but you're going to need to re-verify them if that's the document that they're choosing to provide at the time that the document expires.
not if it says INS on there.
INS doesn't exist.
I get those.
You shouldn't get those anymore, so.
So we want to re-verify the work authorization, but if I'm auditing and their resident card is expired, that's what they use.
You cannot re-verify them. If the question is if they presented a lawful permanent resident card and it's expired, do they need to re-verify? You cannot. It's actually discrimination to re-verify a U.S. citizen or a lawful permanent resident. So you don't have any obligation to re-verify a lawful permanent resident. Okay, I'm going to take one question. I'm going to stick around, I think, in the back because they're going to transform this room at lunch, and I was told I had to be on time. If you haven't done so already, we're going to be raffling off an Amazon gift card and a free telephonic consultation if you're interested related to I-9 compliance. If you have other immigration-related issues, I'm happy to help with those as well. So please see Bianca and give her your card. And I'll go ahead and do a raffle in just a second at the back of the room. So thank you very much.